The second case is USA v. Heard out of the Eighth Circuit, and I'll be quick, but essentially it's not an immigration case per se. It's a sentence enhancement, but essentially the Eighth Circuit is just, it's the year of the isomer, especially in the Eighth Circuit. The Eighth Circuit said that Minnesota MDMA, ecstasy, from at least 2011 and a bit earlier, is overbroad and indivisible vis-a-vis the federal definition of MDMA. It has an extra isomer, whatever that means, and which essentially means that conviction for anything related to MDMA, at least from Minnesota from July of that year, is not a controlled substance offense. It's overbroad and it's indivisible. I mean, and by my count, I'm not going to get into the whole isomer argument, and cocaine has isomers, MDMA has isomers, some of these other things have it, but by my count, only just in the Eighth Circuit, Missouri cocaine, and these are all definitions based on certain years, but Missouri cocaine, Florida marijuana, Minnesota cocaine, Minnesota MDMA, all out in the Eighth Circuit, depending on the years. And of course, there's Syed in the 11th Circuit that is also saying Florida marijuana, the same thing that the Eighth said. There's the 7th Circuit with, I want to say, Indiana something or other, one of the hardcore drugs. Yeah. So like the isomer thing is, it's all happening after all these years. By my count, the 8th, 7th, and 11th have all adopted at least the idea that a drug itself can be overbroad vis-a-vis the federal definition of that drug. So it's not just the schedule of drugs, but it's the actual definition of drug itself. And Florida marijuana, I just did it for a case. Florida marijuana, that definition hasn't changed in forever. Like, Florida has always criminalized possession of the unsmokable portions, and the federal government has not. And so, like, don't take my word for it, but like, Florida marijuana isn't anything.
Yeah.
Ever. And if you're gonna buy the isomer argument, I think a lot of doors open. Even if Minnesota MDMA is now aligned with the feds, pick your state. Like, that's 50 different states with 50 different definitions, and it's quite the world we find ourselves in now that circuits are buying the isomer argument.
Do we know who the first lawyer was who figured this argument out and started arguing it? Who won it?
I don't know. I know, and so when I talked about it on the podcast, when it all started happening like 2 years ago, an attorney reached out to me, and I was aware that actually the first court to, I think, buy the argument was the Ninth Circuit a few years ago, maybe 2017 or earlier. But then it seemed like the Ninth got cold feet, and they walked it back in that decision. They reheard the case again. They issued a new decision. They said, oh. And so I don't know who the attorney was on that case, but if I had to answer your question, I'd say it was whoever was the attorney on that Ninth Circuit case. But I'm sure this argument's been floating around a lot longer than me, and a lot of it isn't happening in immigration anyway. It's the federal public defenders who are making these arguments a lot of the time, because it's the same analysis for criminal defense, sentence enhancement.
I see.